Okay, we're on, man.
All right. Well, I heard your last hearing and the entire diagnosis of it, which I thought was one of the best so far. And so, how do we approach it? Do we? One of you guys, big boy, you got your mic on? It's making noise back there. Just mute out unless you want to talk.
All right, move it.
Oh, holy moly! That's major gain there, bro. Turn that thing down.
All right.
Anyway, so Paul.
Yeah.
Do we start where the judge, let's assume there's going to be two possibilities. One, it's going to be a completely different judge and he has no clue of what's going on, which may be good. Or two, you're going to have the same judge and he's going to say, okay, I remember this clearly. Remember what he said. He said 15,000 cases and this one sticks out. So he's going to remember you. So where do you want to take it from? You want to take it from that one?
I'll just clarify the there's a new judge, so that's for sure, and so it's in a new court, and the judge, the clerk for the new court requested that the prosecutor respond to the three motions that I had on the table. So yesterday in the mail I got the prosecutor's response to the three motions. So Troy, and just so you can get up to speed on this, and Tom as well. Gary, are you on the call?
I am.
Oh, great! Thanks, Gary. Appreciate it. Dan, are you on the call? Okay.
Yeah, I'm here.
Okay. So we got Dan and Gary and Troy and Tom. Excellent.
Yep. And we got a new guy on here too, but good. Anyway.
Yeah. So Gary, do you want to be Miss Kershak? I'm just kidding you.
Sorry, could you repeat that?
I was just kidding you, man. I was just asking if you wanted to be Miss Kershak, the prosecutor.
Oh no.
Okay, so I'm just kidding. So anyway, let's just I'll just set the table here. So I had the my motion hearing. I'm sorry. I'll just try to slow down here. My initial appearance was waived, and I had a motion hearing instead. I had a motion to dismiss hearing on March 13th. And
did you really?
Good, yeah.
Now,
good.
Wait, Paul. Just for my clarification, was that the one that was on that recording?
Yes. Yes.
Okay.
That was it. Yeah. Thanks. That's a good point, Gary. I really didn't have a valid hearing because the judge was so biased. So
yeah, see, don't say things that aren't true.
I catch me on that, man. Don't let me get away with it. So then I filed three motions. I filed a motion to vacate the plea that he entered for me over my objections. I filed a motion in motion in limine to stop the prosecutor from proceeding absent beyond the facts or absent facts and evidence of jurisdiction. And I asked that they
stuck a for me in there.
Oh yeah.
Quit already.
You gotta stop.
Go on, Paul. Keep going.
Yeah, he entered the plea. He entered a plea for the prosecutor, and then I asked to consider the motion to dismiss. So yesterday, I got in the mail. I got a response from Miss Kershak to these three outstanding motions, and her response, it's just it's rubbish. Her response is rubbish. So I don't expect you to.
Are there any bona fide objections to the motion in it?
When you say bona fide, no. She either creates a straw man or alludes to the straw man that the Judge K created.
Okay.
Or she simply cites the code. She's saying Statute 800 gives commencements of action, gives us subject matter jurisdiction. She asserts that I voluntarily came to the court, which gave them in personam jurisdiction.
Oh yeah, they love that one.
For that.
Pardon me?
They love that one.
Yeah. That again, the premise is always, and she needed to, and she had to, and she relies upon it. That lie is one that they need you to cooperate with.
Yep.
The idea that you voluntarily come in.
Yeah, I've had a prosecutor right over me and say, "You showed up," because I asked him, "How did you get jurisdiction over me?" You showed up.
Now,
it.
Now, not that they won't back off on something else. They're, for personal jurisdiction, but they say, well, because you showed up voluntarily, they don't need to provide any further proof. That's not one of the things that is anymore in their little burden of proof basket.
Mm-hmm.
Again, they need to get it in there that you voluntarily are there to resolve some matter that you feel some kind of a obligation to resolve.
So, okay, let's keep going though. So now he sent 3 motions after that hearing.
So his objection to the motion hinges on that falsity, right?
His objection to her, because she just responded to it with a bunch of minutia.
Yes.
So he's going back in now on Monday with that response.
Okay. Okay. So, but what I'm saying is, you still need to look at the things, even if she just gathered up a pile of crap.
Oh yeah, absolutely. I'm picking it.
So she's saying that there is, with a grain of salt, because the subject matter jurisdiction relies on standing, but the other part of subject matter jurisdiction, like as in which court is designated to that, if there is subject matter jurisdiction in the whole, that court has subject matter jurisdiction because of the designation from the statute. So she ignores one half of the question, and then she goes on, okay, personam jurisdiction is because you're voluntarily there, right, ignoring the gun in the room.
Mm-hmm.
She probably went into, territorial jurisdiction is because this, occurred within blah, 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 right?
Well, the fifth element of the motion to dismiss is the challenging the fact that they're saying that the laws of the state of Wisconsin apply just because I'm in Wisconsin, and so she just goes on to cite that
it's a conflation, right?
Yeah, she just goes on to cite that I was on the highway, blah blah blah. Her whole
she's saying that they're the same thing. She's saying that physical presence on certain area.
Mr. Mosina, we heard your argument. Mrs. So-and-so just clarified it for you again, and we're standing here again. It seems that you had this argument before. What is it that you do not understand about it?
Well, just hang on a second, Tom. Just let Gary finish his point.
Ahead here a little bit.
Let's go on one thing at a time. You know what happens?
We're on one thing at a time. We're trying to jump to the next thing.
Yeah, that 2 hour and 20-minute fucking ordeal. There is so much to absorb there, man. One little piece at a time, and let's use those.
So let's stay at the piece that we're on. You're trying to jump
right.
ahead.
Oh, I'm sorry. I thought I was staying on what we were on.
Oh, okay. We thought you were trying to jump ahead, so go on.
No. I think what we're trying to do here is set the table on what we want to try to accomplish today. And Gary was just trying to summarize what was the gist of the prosecutor's response.
Well, you'll need to. I mean, part of what you'll need to do is to show that response to be hogwash, right?
And that's why I went right into it. That's the whole reason. I just said, all right, Mr. Mosina, I've read the motions again.
Okay, how about the underlying thought first? I mean, you're telling him to role play a thinking before we've even defined what that thinking is.
Why don't we go?
I was just wondering what Paul's summary. Yeah.
I'm sorry, Gary. Why doesn't Paul read through her response line by line?
So we line by line. He can summarize. But
I bet it. I bet it's only 3 lines, Gary. Trust me. Am I right, Paul?
Okay.
No, it's more substantial. I mean, it wouldn't take long.
You can skip the code parts. How about that?
Well,
it doesn't matter what her response is. It's bullshit. That's my point.
Well, yeah. I mean, I think we can just.
That's still bullshit. You have to address.
Right. I think we can just summarize her responses that she's completely relying on the code to establish both subject matter and in personam jurisdiction.
Oh, well, in personam is established by your volunteer appearance is what you just summarized. But the code that she's relying on the code without facts, right? So her reliance is without evidence.
Right.
Okay, so let's take it right from there.
Unless some code somewhere mentions evidence, like, hey, by the way, we're talking about when he was blah blah.
Went through that on the last 2 hours, so here we stand. The prosecutor just said your motions is a bunch of bullshit. I'm now the judge. Paul is in Monday morning, and Paul brings up this motion again, and I go, look, prosecutor already denied it. We've already had this discussion before. I went through this, okay? It's exactly word for word what I had. All right, Mr. Mosina, we've already heard your arguments.
Well, if it's been responded to, it's not denied. I mean, don't misstate the current scenario, right?
Well, this is.
He'll make that decision in his own chambers. I've read it.
But Gary, I can see a judge saying that.
Well,
Oh,
yeah,
I see
yeah,
what you're
that's
saying.
me.
Where I'm denying, where he denies it right at the outset, and that's the stage that you're up from.
Dude, I was walking through the gate when I called that bitch Mary. I hadn't even got to the desk yet. I read your motions, blah blah blah. It's denied, and I'm getting there. It's like, what? You know what I mean?
Yeah, she's just going through the motions. Officially, she denies everything, right?
That's what he's going to get tomorrow. That's my point. I want to skip into.
But don't skip that. Okay. So as a matter of due course, they're going to deny it because that's the safer move from their career standpoint. Denying your motions is pretty much a given safe move for them, right?
Mm-hmm.
That's right. And now I want to see what he's going to say.
Okay.
Mr. Bozina, I read your motions. I denied them. They seem to be the same thing. The argument is the same. And how do you plead?
Objection. A point of clarification. Am I entitled to a fair and meaningful hearing here?
Well, actually, I entered a plea for you last time. I want to refresh. I entered a not guilty for you on your behalf because I really think you want to get your case in court. That's right. He's going to – okay. All right. He's going to see. All right. Let's go from that point. Mr. Bozina, I see that Judge Knucklehead before you.
He's probably just going to say, I see a not guilty – or he's probably just going to skip it and say the not guilty plea standing.
You have a not guilty plea here right now. And I read your motion. And Miss such and such has explained it, and I deny your motions. How do you? Are you ready for trial?
Objection. I have a point of clarification. I'd like to know what are the factual legal basis for your decision. Is there a specific element of my motion to vacate that you had a problem with?
Well, Mr. Bozina, it seems that Judge so-and-so had already entered a not guilty plea. I don't understand. Are you ready for trial? I don't understand your question at all. It seems you're ready. You want to go to trial, right? You want to have your day in court.
Objection. A point of clarification. The purpose of the motion was to call into question the context and circumstances in which Judge K entered that plea for me. Did you read the motion? Was there a specific do you have a specific objection to my reasons for asking that the not guilty plea be vacated?
Well, Mr. Bozina, I want to assure you, I want to give you your fair day, and I read your motions. I actually read them twice, and I got the response from the prosecution, and I've told you I've denied it, and I don't even need to give you a reason for it. So, are you ready to go to trial?
Objection. I'm not ready to go to trial. The
1, 2, 3, man. 1, 2, 3. Pick one.
Yeah. The prosecutor. Can you point to anywhere in the prosecutor's response?
Sure. I've had enough of this. It seems that we've gone around this before, and I just need to know if you what would be a convenient date for your trial date, sir. I'm trying to make this fair for you. It sounds like you really want to defend yourself.
Objection. Point of clarification. Do I have basic human rights here that include the opportunity to get notice?
Question. Back that up. Stop. Back up. You got a much easier question than that. If you ask that complicated of a question, he's just going to fart in your general direction.
Okay.
Brief yes or no questions.
Okay. Well, objection. Point of clarification. Do I have basic human rights that include being informed of the nature?
You just can't make it. You just can't make a sentence. It's a little sentence, can't you?
Okay.
You want semicolons and shit in there and everything.
All right. Am I entitled to be informed of the nature and cause of these proceedings?
Sir, yes, and you have been from what I saw, what I'm holding in my hand, and all I know is there's a not guilty plea entered for you, so you had your opportunity. What is your problem?
Well, objection. Do I still have the right to plead guilty here today?
Oh, of course.
Do I have the right to make an informed plea of guilt?
Absolutely.
Do I have the right to be informed of the nature and cause of the proceedings?
Well, again, it seems that you must.
That's a yes. Objection, Your Honor. That's a yes or no question. Do I have the right to be informed of the nature and cause of these proceedings?
I'm gonna advise. I'm gonna give you a little advice.
Okay.
Yeah, running into the middle of his sentence before he's even managed to get anything out is not going to look good for you.
Well, that's the same problem. I caught myself doing it too, Gary. So that's the same thing I did last time. So you're right.
We're practicing. That's what this is about, bro.
Yeah.
So anyway, as we were, forget where the hell I was now. Again, of course, where did I leave off? I asked you, of course, for a plea, and I had reasoning behind it. What was it? I'm off track.
Well, I mean,
It doesn't matter. It doesn't matter.
Back up and ask
I
a
don't need
simple
to back
question.
up. I can go. Yeah.
Not you,
just,
him.
go.
It was his turn, but that's okay.
All right. Well, again, Mr. Mosina. Again, I've read. I've denied the motions. I really need to set this for a trial date. I don't understand your question. Prosecution doesn't understand your question. Make your next question.
Objection. Are you? Is it an arbitrary opinion that you rejected the motion to vacate the plea?
Sir, as I've explained to you, I do not need to give you reasoning at all. I've made my rulings on your motion, and that's
Your Honor. This is the clerk here. We have openings for Wednesday and next Tuesday for trial dates.
Objection. Point of clarification. Are you saying you don't need to give me the rationale behind your decision? Let me just write that down. Is that what you said?
Sir, I don't need to explain myself to you at all. This is my courtroom, and I made a decision, and I don't want to hear about it again. So now, what would be a good court date for you?
Objection. Point of clarification. Are you denying me my due process right to be given notice and an opportunity to respond and inquire into the nature and cause of the proceedings today?
Sir, you will be given all your constitutional rights, and we'll make sure that at trial that you will be given all those rights. You'll be treated fairly. My court is the fairest court in our county. Ask anyone.
Objection. Point of clarification. Has the prosecution presented evidence as of today, as of right now, that this court has jurisdiction, that the codes and statutes of the state of Wisconsin apply to me because I'm physically in Wisconsin?
I would say apparently so, because the judge entered a not guilty plea, and it's now scheduled for trial. So apparently there has been, the evidence is entered. So again, are you ready to go to trial, sir? You're really trying my patience.
Objection. Point of clarification. If you say you found that evidence and you have that evidence, can I see it?
Well, I was assured, Mr. Prosecutor, is that evidence in the files? Mr. Capps.
Yes. The file is complete.
There, Mr. Mosina, it's all in there. Again, this all I know is I have this in front of me right now. I'm scheduling it for a trial. I don't know anything else about it. There was a not guilty plea entered for you, and how do what would be a good date for you?
Objection. Point of clarification. Are you attempting to force me to go to trial without first establishing by proof, facts, and evidence that this court has jurisdiction?
Well, it seems to be already decided. I don't understand your question. This is your day to decide a trial date, sir, or bring up motions, and I've denied your motion. So we need to move forward if you want to defend yourself.
Objection. Point of clarification. Has the prosecution, as of right now, presented facts and evidence, not opinions, that the laws and statutes of the state of Wisconsin apply to me because I'm physically in Wisconsin?
Well, I like I said, I don't know what this is all about. I have this paperwork in front of me. Obviously, he did, and I just asked him, and he said it's all in the files. And
Tom, you think a judge would really be this? I don't know, nice?
Well, if I'm not, then this thing will end. I can't go.
Yeah, I know. You're trying to play along with him a bit there, though.
Yeah, I was going to just ask him if I could ask him Paul, if I could call him Paul. You don't mind if I call you Paul, do you? I heard that one. That was a good one.
Oh,
I was right at him. Well, can I call you Bill?
Wish.
I
wish. Yeah, I wish. It's like I'll call you Judgy Wudgy.
Yeah, the only way we can keep this thing going, and you see I'm throwing some different angles at you, Paul. You are definitely being stumped. And I'm trying to do it nicely because, again, that's going to be their nicey nice thing.
Yeah, I mean, they would be focused on is it Wednesday of next week or Thursday? That's about all they would care about.
Right. Well,
getting
I'm trying
a Wednesday or a Thursday from Paul. That's all they would be single-minded in that pursuit.
Well, Gary, you know what? You play judge for a minute. Seriously.
Oh, okay.
Or how about this? I got a better one. Mr. Mosina, you play judge, and I'll play you.
There we go.
Okay.
All right. So I'm walking up to the gate right now. You've got my charges, and you're a new judge, and you know that there's a not guilty plea entered. And now technically,
you know that all paperwork wise, everything's done. All you need to get in order to get a win in your column is for him to indicate in any way, shape, or form that Thursday's good for him, or Friday, or whatever. That's it.
Because
That's all you're trying to get.
Because all you got to
get in is that's denied, and for a win, complete win point from you, is that you get him to say, yeah, Thursday, whatever. That's all you got to get.
Okay. Mr. Mix, I've reviewed the prosecutor's response to your. I've reviewed the prosecution's response to your motions, and I find they have merit, and I've denied your motions. The not guilty plea entered by Judge Case stands. We need to schedule this for a trial. How about next Thursday?
Well, sir, I tried to enter a plea before, and there seems to be a plea entered for me. I'd like to ask first, is there a recording being made of these proceedings?
No, sir. The municipal courts are not courts of record.
So, wow, that's interesting. So, no matter what happens here, it's my word against yours. Is that correct?
The clerk of the court will establish the procedural and substantive actions taken in the court, but beyond that, yes.
Well, then I see no point in it until there's a court on record. I have nothing to say.
Okay, well we'll just schedule
we're scheduled for Thursday.
Yeah, then we're just gonna Mr. Mix. If you're gonna stand mute, we're gonna proceed and schedule you for Thursday, and we'll see you in court on Thursday.
Awesome. Will that be on record, sir?
Yes. The procedural actions taken by this court are being recorded by the clerk of the court. The verbal dialogue is not being recorded, but the actions and decisions made by myself are being recorded by the clerk.
You're thinking lawyers don't do this much confessing.
Hold on a minute, Gary. Sir, so when I come back next time, this will be now considered a formal court, and there will be a record being made?
No, sir. Municipal courts are not courts of record.
So there's no record being made whatsoever.
There is a record of your appearance and the decisions that are being reached, and any motions filed and any contempt charges issued. That is the extent of the record made in this municipal court.
Well, I'll see you later. I mean, I don't know what to say, Gary. I've gone through that.
Why not?
Because,
Why do you
dude,
think
I've
that?
gone through. Listen to me. I'm telling you, I've gone through traffic shit here where they have specific cities here that don't record the very first hearing. They are absolute fucking tyrants. It makes no difference. You have nothing you can appeal. There's no record. All there is a record of the decision.
Hey guys, let me interject real quick.
Language here. Okay, go ahead.
That was my case as well, but I stood on that point the first month in court. I said I cannot participate in these proceedings if there's no record, because if I'm going to form an appeal, if there's no record, I can't do that. So I cannot participate or say anything to you because it doesn't mean anything. I could say something, you could say I said something, and it just goes back and forth. It's all hearsay. So unless we have a record recording of these events for my appeal, there's no need for me to say anything. It worked.
Okay, so let's
not saying that it's not going to work every time.
I agree with you. Let's clear up some muddy language. There's a real bad muddy language problem here in the middle of this.
Gary, it normally moves
Just to be
up
clear,
to
a court of record has nothing to do with a recording.
We understand.
Okay.
We understand that.
All right. So don't use those interchangeably.
It's not the same thing, though. Unless you go into
they're not related. A court of record and a court with a recording are two unrelated concepts. They can have both. They can have neither. They can have one or the other. They're not related.
So what's the difference? Stop right there. What's the difference?
What's the difference between a court of record and a court with a recording?
Correct.
Okay. So there's four possibilities. One with neither. It's neither a court of record nor a court with a recording. Okay, that is an administrative procedure is all, right? With just a without some No,
Yeah.
I have somebody objecting to what I'm saying. So, okay. Court of record gets into some formal definitions about how it's proceeding, but the recording itself, you can be recording, and he's very sad. Anyways, you can be recording the events themselves are the record. Okay.
But who's
Now,
logging?
if you're proceeding in a certain manner, there's a tradition of calling a court of record something proceeding in a certain manner.
Gary, I want you to clarify that because you keep saying that, you keep falling back on that. The events are what actually happened. Who's recording those events, and how are you going to bring that back?
Wait. All right. So we're dancing around the difference between a recording and a record, and an event, and all that kind of stuff.
Yeah.
Okay. So something that is on the record or off the record. There is no such thing as off the record. Okay? Now, a recording is a completely different concept that was way after record.
You just made an assertion, and I want to hear the explanation. You said there's no
there. I'm trying to differentiate the words here a bit. And
all right. I've been hearing this for a long
question.
time, and I'm still not clear on it whatsoever with what you're saying.
Let's try to make it clear.
Okay.
Okay, so
Court of record.
Well, again, there's a whole ceremonial definitional history behind court of record, and that gets into a big old ordeal.
Can I use it in an appeal court, an appellate court? That's what the court of record means to me.
Well, I don't. It doesn't matter what it means to you. I mean,
they go by the transcripts, right?
It might be
right, and there aren't any. That's the point.
And separate the notion that an appeals court will deny review of anything that doesn't have a certain ceremony completed is not related to any of these concepts, right?
Okay, that's what you keep saying. But without that recording or without that transcript, Gary, exactly how are you going to fucking argue something that happened that is not recorded? That's what I want to know. I've heard you say this many, many times. How are you going to do it?
How do you raise an appeal issue based upon events rather than some court reporter's rendition of those events? Is that what you're asking me?
Yes, sir.
So when you raise an appellate issue, you're writing an appellate brief, correct?
Yes.
Okay, when you write an appellate brief, are you including the record? And are you saying that the only way they'll accept it is if that record's included?
That's how I found it. If you don't have the transcript from them officially printed out, and you know how that can be fishy, but so far all I'm... Okay.
It's true. Even if you have a recording yourself, the appellate court will not listen to it at all.
Right.
No, of course
you're
not.
saying
Nor would I.
that a court of record, you're saying the court of record, everything is on record. It's just not annotated.
In the universe, everything's on the record. There is no such thing as off the record. That's not something
you just want to get the transcript so you can use the transcript to prove that they denied due process.
But they don't make one, Dan.
But the central concept that we're talking about is that certain appellate courts resist reviewing anything if they can't get a transcript. Is that what we're talking about here?
Correct.
Yes.
That's the only concept we're talking about here.
Well, why don't you just ask them, can I get a transcript of these proceedings?
No,
how do you go about getting a transcript?
How about this for the question?
Hold on,
how about,
Gary. Dan, that's the
point. A different point.
But Troy and I, and now Paul, are in courts where they say, nope, there's no record being made.
Fine, but you're omitting the real question. The real question is, do these proceedings have any appellate proceeding? Is there any appeals process for this hearing?
I don't know. Is there?
Well, that's a clarification question. I'm not asking you. We're asking the judges.
The judge that.
Well, okay, that's what they'll say.
And if he says no.
No, they'll say yes, because I've asked that. Listen, when I asked if there's a recording being made and she said no.
You stop saying I'm saying something different than I'm saying, Tom.
No, she said all you have to
It's
do
not
is
what I said to ask, and you changed the question.
Hey, Tom, let him finish real quick, Tom. I want to hear what he has to say, the rest of it.
Okay.
Go ahead, Gary.
Stop changing my Tom. Stop changing my question. The question I asked the judge is not, is there a recording being made? That's not relevant. The question I asked is there an appellate process for these proceedings? And you keep changing that into a recording or a court of record and all these irrelevant factors. The true underlying problem is there an appellate process for an error made here? And if he says no, then I agree with you. And then suddenly I come to agreement with everything you guys have been saying about what you're implying from the other.
Okay, so let's get a scenario. So you ask that question, and he says, yes, there is an appellate process to this court. Yeah. At that point in time, what do you say?
Okay.
What would you say?
So, again, clarifying, it's like, okay, so let's say you made an error and gave me faulty information here today. How do I raise this to your appellate,
$160 bond, and you can go appeal it. That's what they'll tell you.
So is there an appellate process that doesn't further injure me if you injure me here today?
Sir, I've had enough of your questions. I've got a lot of cases before.
Obviously. So we get to a point where you no longer answer the questions, right?
Yeah, that's what I'm trying to tell you. He's going to a court right now that has no pressure on them whatsoever to follow the rules. And their thing is, Mr. Mozina, if you want to appeal this, pay the bond and step it up. That's what this is about. He's in a court just like I was.
Now you just change your position into there is an appeals process and there isn't. You got to pick which there is.
No. That's what I said. If Paul refuses to argue this thing and loses, let's call it, in this thing tomorrow, Monday, the next step up will be a court with recording, and that's what he wants.
Okay.
That next step will be a district.
Okay.
I think that's a mistake. That's a mistake because you're letting them proceed further.
But they're trying to proceed the half-assed way first.
Gary, listen, Dan and Gary, I had a woman, and not the one that actually fucked me on this one that I lost, not that judge. I had a woman magistrate, and I watched her. She knew, and I asked her specifically, is there a recording being made? And it blew my mind. She says, no. That was this other city. And she says, no.
Relevance?
No, my point is, I watched what she did, and I challenged her. She had nothing to lose. And she said, you can appeal it, just pay the $160 on the way out. And then it moves up with a record.
Okay, I get you, and they probably do a trial de novo.
With arguing with her, practice. That's it. What Paul's going to do on fucking Monday is practice. That's it.
Okay.
Don't mean nothing.
But arguing with her is just a way for you to get informed, to receive information. That should be your only goal. Clarification, right?
And being careful.
You're going off on these tangents.
Listen,
you're going off on
off to the side.
My objection.
Look, Gary, I'm serious, man. This is no game. I had 4 cops standing to my right at ease. I remember the one where I'm just saying, she knew this was a magistrate, no record, no nothing. You are taking your ass into your hands fighting these fuckers with no record at all. Fuck that.
Agreed.
Go home.
That's the thing. I agree with your conclusion. I just don't agree with the premise that led to it. You're right by coincidence.
What do you mean?
Back up.
I walked into a court where there's no fucking record being made at the magistrate level, period.
Okay.
And she knows it. And they used me. They put me in my own courtroom. The whole place was packed. They managed to find my own fucking room, put cops on the side. Everybody's in there watching this thing and totally intimidating me. Why would I stand there and argue? There's no record, but just pay the $160 and take it to the next level.
I agree with your conclusion. I just disagree with the reason why. The reason why isn't because there's no record. The reason why is because there's no appeal.
No, there is an appeal.
No meaningful appeal.
No.
No appeal that doesn't further injure you.
Gary, this is what happened to me. Exactly what he's going to face on Monday. They decide, okay, you're going to trial. And then it goes to a real court. The next, Paul, you're in the United States, right?
Yeah.
Okay, simple. You're in right now a district court, correct?
No, I'm in a municipal court.
Yeah, exactly same thing. They call it a district court or municipal court. And right now, he's at the lowest rung. He's facing a magistrate, right, Paul?
No, it's a judge.
Are you sure?
I went to the court. So let me just.
Here around here they call them all judges too. They got rid of the word magistrate because it used to impart a difference between the tribunal and the magistrate. Now they've combined tribunal, magistrate, and call them judge. But that's not
okay. Unimportant. The point is, what level are you at? If this is truly, if you ask that question, is there a recording being made right now, and how may I obtain it?
That's the relevance of the recording.
Because he's going to be at such a low level, he needs to bump it up to the next one. That's easy.
Okay, so
there's no
why
point
not say
why
you're
push
asking
number
the
2?
wrong question?
Okay, it's practice. Okay. Don't push number 2.
Let's back up, Tom. Tom, how about this for a point from me? And I understand you just keep going straight back to what you're trying to assert. Hold on.
Okay.
You clarify that you'd like to make a recording so that you can have it reviewed by an appellate process. He says, fuck off, no way.
Yep.
You say, well, is there an appellate process that can review the actual events here today?
Yeah,
and they say, whatever the hell they say, right? They come up with whatever, and basically because they're just trying to do a backroom deal and call it a court and intimidate you. You know, this is a less formal process, but with all the formalities and guns pointed at you of a real process. I get that. Okay.
Yep.
So your conclusion that it's worthless, I somewhat agree with. It's not a great thing.
It's practice. It's going to be great practice.
It can be horrible practice, and
be careful. If you're going to do anything, be very, very careful because you're walking out of there losing.
Because
they'll
say they have reason that you lose, and that'll be what gets. That's the only thing that gets recorded is their conclusion, right? The one thing that manages to get recorded is the fact that they found that you were guilty or whatever.
The disposition, exactly, and you want to get that, by the way.
Okay.
Paul.
Well, you don't want to get a disposition from them. You're not interested in disposition from such a fly-by-night.
Gary, I'm saying after it's all done, he wants to get that disposition in writing. He can get that. That's the decisions. That's the only record.
I would be thoroughly uninterested in their opinion.
Why?
Because it's not based upon evidence and procedure and due process.
Yeah, okay. All right, whatever. You're right. I mean, it's going to move up. What happened with me was it moved up into an actual same municipal court, but now to a real judge.
I understand. I understand.
And it's real easy to do.
And the objection I would have is that I got dragged into a non-court, to an informal setting where, this guy's errors had no review, right?
Agreed, but and it'd be fun to argue it. It's going to be fun to argue it. But that's it.
And
I totally agree. You can have fun with that thing on Monday, Paul. It's just going to be. You're not going to get it resolved Monday. I don't care what you fucking argue, because that guy has no record being made, and he is not going to let you off the hook on the next.
It's a win-only scenario for them.
Yeah.
Right. It's a no-lose scenario. They can only win. And they can't lose.
Yep. And so you can have.
That's why they love this.
And relax. You can actually walk in there a little bit relaxed, but you know you're going to lose. And you're going to
no. Oh my God. You shouldn't be winning, losing. You should be pushing for information.
Dude,
and once it's clear that you're not getting information, you should be thoroughly disinterested in any rendering of findings or whatever their dispositions from them.
Yeah, so
it's like I'm not asking you for a disposition because we've not had a hearing. Now a hearing is opportunity to be heard and all that fun stuff. Now you should be taking notes. You should be saying here I have some questions and you just it's the same scenario as ever. You have an open question on the table and they're not answering it. The impasse is the fact that you have the right to know this information, supposedly, and they're not giving you this information. And the prosecutor's failing to do his job in making sure that you get due process and that you get this answer.
Right, well,
that's the whole story, and it doesn't even get into what do you care if what do you need somebody to take notes for you to tell you if you've got the information or not?
No, this is
the fact that there's an open question on the table.
So it's practice. So here, all right, Mr. Capps, you're the judge.
Well, no, it's not practice. It's the opportunity for you to keep an open question on the table.
To whom?
It's an informal hearing without a recording, but you can take notes. You can put the question up there. You can read it verbatim, and you can say, I'm still looking for this answer. That's all that occurred here today is I put a question on the table, and you guys danced around not answering it.
Well, when he goes to the next level, he's going to enter all the exact same motions. Everything's going to start over exactly the same.
Sure.
So tomorrow he's going to walk in, and in my opinion, that simple, I don't know, Paul, you've seen the concept of cornering the judge with questions, right? And then bringing their own answers back to haunt them.
The softball yes or no's, the softball questions, getting those answered, and then showing that supposedly you have the right to get an answer to a question they're not wanting to answer.
That's all you're going to be able to do in a court like where he's going. So you're going to have to be nicey nice and tricky. And I tell you what.
And you want to make clear, that you're trying to plead guilty and make an informed and knowing and voluntary plea of guilty.
Try this, Gary.
Close my car.
Second.
Okay. You guys still there?
Yeah.
Let me just jump in for a second now, because I was really kind of interested in this very question myself and trying to learn the difference between a court of record and a court where an audio recording of the verbatim discussion is being made.
You want to go down that rabbit hole? There's some good information on.
It's not a rabbit hole, Gary.
I'm just trying to get facts. Let me just finish. I'm just trying to.
Books written on what a court of record is.
I'm just trying to get educated on
criteria.
Right, but I was trying to get educated on what I was going to be dealing with. Now I went to that court, and it was very informal, and the judge. It didn't appear to me that there was any audio recording being made, and there. In their municipal court context, they think a court of record is merely the recording of motions made.
I bet you they don't. I bet you they know better. Now, they might
give you the
impression that it's interchangeable, but I bet you they know better.
They do know better. So, hey, Gary, so what you're saying, Gary, is the fact that it's a recording or not is really irrelevant. It's the fact, is there an appeal? Is there an appeal process that has information that can be reviewed, right?
Yes.
Is there a appeal that has information that can be reviewed? Yes or no? And there's not because there is no court reporter. So basically, there's no need to go forward with that because there's no reliable way. There's no reliable way to communicate to the appeals board what happened.
And that could be good.
So you know it's not a recording, so you just use that to your advantage.
I don't care if it's a recording. I don't care if it's a guy taking shorthand.
Gary, I used it
no record.
I used it to my advantage at one point because the cop's testimony wasn't on record. There's no record.
Record. There is no such thing as off the record. The universe does not include such a thing.
We're not talking about, listen, you got a weird different angle on what I mean about record. If I'm standing in a courtroom and a cop says things and I say things and there's no transcript being made, to me, that's not on record. And when I went to the next step,
you keep jumping over to the other definitions. Stop
hold on a minute. I went to the next step, which was the first appeal. They couldn't use his testimony because it didn't exist. Do you get it?
Because it's not that it didn't exist. It's because they didn't have a reliable way to keep that it would have been communicated to them.
And my point is, it was my advantage. There was nothing against me yet.
Okay, I'm agreeing with you, but your premise is wrong. Your conclusion's correct. They had nothing to work with. Your premise is wrong about why they had nothing to work with.
Gary, my point is the next step that he's going to go to, it's going to start over. It's going to start at absolutely step one.
Well, they're going to try to imply that you've already been. They're going to try to imply that you're starting at step guilty.
Hold on, Troy's cutting in and out.
Sorry. Hold on, guys.
And your phone.
Hey, I don't mean to interrupt, guys. How do I add someone to this call?
You what?
How do I add someone to this call?
To a call in progress, Skype doesn't really have a way.
Yes. No, you'll lose the call.
Okay. All right.
Anyway.
So Okay, go ahead.
So, Gary, I understand everything that you're saying. All I'm saying is, for practicality-wise,
don't say the word record and recording as if it's interchangeable. That's all that's what's getting under my skin here. That's it.
I understand.
If you stop doing that, fine.
Okay, I'll use a different word. All I'm trying to say is this thing he's going to do on Monday is not going to be technically recorded that he can use it against them. And it's a good way of it's good. It's two things that are good.
He can record it. I mean, he can write it
but
down.
He can't submit it. It won't be acknowledged. So neither
acknowledged by the appeals court.
What?
Okay, so you're saying it won't be acknowledged by an appeals court.
It's not even an appeals court. The next step he's going to go to is the same. There's going to be another judge in the same fucking court building, and it's going to be called a district court.
And they won't acknowledge anything except for the disposition,
right?
Because everything else cannot help them.
Exactly.
So they boil it down to the things that can help them. They boil it down to the things that can help them, which is that you were found guilty or something like that.
Yep.
Correct?
Responsible.
Okay, so don't say step one when you don't mean it. You mean step you guilty, right? That's not step one.
It's actually step responsible. Am I right, Paul? You have an option to operate.
I don't care what they rephrase guilt as responsibility.
All
as liability.
Just to be a little bit particular, it's good. They're going to start crying that it's a civil issue, and you don't understand, Mr. Mozina. This is not we're suing someone. They'll give you all this. I can play you that on you too.
Spin your head around with the words, of course. I understand. Okay, anything but innocence. Okay.
Yep. So
how about we just have two categories: innocent and anything else. Okay.
It's not that simple for the court. If you start saying that
because they're trying to play word games.
If am I presumed innocent of this crime? They'll say, sir, it's not a crime; it's a civil infraction. You are responsible or not.
Am I presumed innocent of this accusation? That's why I avoid the word anything else.
That's all I'm saying.
I don't care if they call it a sin or a crime or offense or whatever. There's two states: innocent, which means they should leave you the hell alone, and not innocent, which means they can screw with you.
Yep.
There's only an accusation. I don't care what kind of accusation it is.
I like it. Yep.
So I cut away all of that, and that's why you hear me say innocent, not innocent. That's why you hear me say.
Of an accusation,
accused, not defendant. I don't care for the words defendant. That pulls in all kinds of garbage. I'm accused. Well, I'm in the process of being accused because he hasn't even managed to finish that yet.
Right. Well, my prediction is this: if Paul does his thing on Monday and has some real relaxed fun and really. Because of the relaxedness, being able to use his logical mind, because he was great on the first hearing, they may actually go, you know what? It'll just disappear like Travis's did.
Yeah, disappear or some timeliness problem will come up.
Yeah.
Oh, we didn't get it filed in time, or something happened. We can't schedule
it. They're not going to want this to actually go to a court of with it already, Gary, recording. Okay, they're not going to want it to go to the transcript.
Okay. If you use the word recording instead of record, you don't pull in all that common law. See, court of record has very, very particular meanings.
That's why you have a problem with that. That's not what I'm referring to when I mean a record.
I understand, but it is what they're referring to. So you got to use the term. You got to watch your terminology. Okay. So there's all kinds of rules. A court of record, you might as well say King's Court. Is this a King's Court? It's not really relevant. Okay.
So at this point, Paul, are you on board with what we're saying? Do you understand this?
Well, I'm following it very closely, and I'm just trying to get the nut out of it. Should I or should I not bother asking them? I already know it's not a court of record. I already know that.
Yeah. That's no point.
So should I ask them? But should I ask them if their audio recording or transcript is going to be available? Is there any advantage to asking that?
You can ask if this is if there's any due process here.
I mean, just for grins and giggles. I always ask it.
Root of it.
I always say, is there a record being made right now and how may I obtain it? That's what I say all the time. Is there a record being made right now, and how may I obtain it? If they say, well, no, then you know where you're at. And now you can
why
have
are you trying to shift responsibilities to them?
I'm not shit. I want to know if I can get this fucking thing so I can go to my next step and what I'm going to have to go to my next step. Although, and I know I'm going to my next step.
I would bring up the fact
that... I'm sorry, Gary. Why is the next step your goal? Why isn't your goal to get it dismissed?
To me,
well,
the stopping point of you have a question on the table that they don't want to answer, end of steps. That's the best outcome for me.
Dan asked a question, and I understand his question. He said, why do I want to go to the next step and not get it dismissed? That's not exactly, he's right. I do want to get it dismissed. But I'm telling you, these judges that know there's no recording being made and no transcript are the most evil fucks you can even imagine. Because they know there's no way for them to be held accountable at all.
Okay, so your goal, I guess your backup, and what all you can do is get them, show that you can show somehow, whether it's recorded or not, I don't know, that they denied you process. That's why you asked them, do I get due process here today, right?
You can ask that, and when they start getting shitty, because of the fact that there's no transcript going to help you, and the bailiffs start moving your way, just say, okay. And you walk out, you pay your $160 or $190, and you get your next day in in front of a real judge.
Objection.
Sorry. It is. Okay, Gary.
No, it's not. It's the way you went. It's not a sensible way at all.
I'm telling you, this bitch just told me straight down, listen, I've made my decision, get out. And the bailiff said, you better get out, one more word.
The objection I had was pay this $160. You keep skipping, you keep going to the trivial part that I'm not objecting to, and skipping the part that I'm really having problems with.
Okay. I'm listening.
All right, so you're saying that there is no recourse other than to pay the $160, and I'm saying, wait, that's a problem. You're saying that your only choice is to pay the $160 because you think that because you're thinking of the wrong next step. That's my point.
Okay, go ahead.
The next step that you're thinking of is a $160 expense, and I consider it a misstep.
How do you get her? How do you get her that at the next step after this fucking cunt just slams you down?
Again,
don't
you
get her
keep saying that next step is inevitable, and it's not the one I would care for.
Well, he's going to give it an argument, and then if he doesn't have a tyrant, she may dismiss it. But if he's got a tyrant,
there's not just dismissal or that next step. That's not the only two options here.
Okay, I'm listening.
All right, so what can happen here is obviously they can decide to put things off and not answer your questions or whatever. Now, are we pretending that there was a steamroll situation? Is that correct?
Yeah.
Okay. In the instance of a steamroll situation, right, where they just shovel on past, declare you guilty, whatever it is, and don't give you any, that wasn't a hearing, right? So you want to be clear that this isn't a hearing. You don't want to make any inference that this is a hearing that you're getting right now. And you should be discussing pretty continuously, hey, when am I going to get a hearing for this, by the way? And they'll say, well, this is your hearing here. Right? Really? I thought a hearing had blah, blah, blah. Notice, opportunity to be heard, things like this. Right? It's an evidentiary. This seems to just be a hearing.
Mr. Capps, you're not understanding. The officer just said you were speeding. We're standing here. I've got 300 people ahead or behind you. How do you plead? You want to appeal this thing because I've already found that you're responsible. So get out. Go pay if you have a problem with it, go see the next judge up. Pay the $160 at the
is tomorrow
rather than going through that we understand that the steamroll happened. I
had that said to me.
I understand that given that the steamroll happened, okay, and you've hopefully, my point for what I just said is that you've made a point to speak about the fact that you would intend to get a hearing and that this wasn't one, right? So now he's shoved you out the building, right? You're outside the building now. You've spoken about the fact that you wanted a hearing and, things like that. And they've spoken about the fact that that was supposedly a hearing and things like that. And that your only other option is to appeal it or pay the $150 or whatever. Appeal it, pay the $150, or pay the fine that he just assessed. Yep. That's the only two options that they mentioned.
Right. When you pay the fine, that is your appeal bond if you choose to appeal. You pay the fine, you have the option.
Hold on. So we're all very clear about the options that they are presenting to you.
Yep. Go ahead.
Much like the do you plead guilty or not guilty, those are the only two options they present to you. They're not going to clarify options that they don't like for you to take, right? Okay. So we need to look behind the bushes and figure out what are the ones that they're hiding that make logical sense for you to pursue your interests without giving them their interests, which is giving them money, letting them injure you further, throwing money at them in hopes that they'll be more fair if you shower them with money.
Right. Okay. Go ahead. I'm eager. I want to hear this.
So other than their two options of screwed this way or screwed that way, what makes sense for you to do? Okay. Now, again, we're making the point that you didn't get anything near an arraignment, you didn't get anything near a hearing, that due process has not occurred. So don't pretend it did and that you're at the appeal step.
Okay.
So, my answer is always clarify. So how do you clarify in a situation?
Because it's done now. You kick out. Yep.
What would you do? What would you do in the instance where you got a packet of paperwork from a city you've never been in saying that you went to this hearing and got found guilty and didn't argue your case well enough and blah, blah, blah? What would you do knowing that you weren't the person that they actually, in this hypothetical situation where you were never in that city, right?
I see.
Would you go to an appeal process? Would you go and say, well, I better appeal that? Or would you say, I better clarify what the hell why they think that I went through some due process?
That's interesting because that still is in my, I have a year before the thing is expired, which will be September 18th, and I'm the same boat. I like this.
So you're clarifying with who's making the assertion? Well, probably the clerk at this point is making the assertion that you got a hearing, right?
Say that again? Wait, start over.
It's probably the clerk who's making the assertion that you've been to a hearing, that you've had a hearing on this issue.
Yep, okay. And it's resolved, and here's the position.
That there's been due process, and it's been a disposition, and it's been resolved. She's probably telling you that you've had your day in court, and blah, blah, blah. You and I know that this is probably not correct.
Right.
But she's making that assertion. Okay, just clarify. You mean by hearing something that doesn't involve due process, correct?
You're going to ask the clerk that?
The clerk, yes.
Okay.
We're clarifying. The person making the assertion to you is the one who you clarify to and who you figure out if it's arbitrary or based upon evidence. Right?
And you're going to do that with the clerk.
Whoever's making the assertion. Who's telling you that you had your day in court?
Okay, I don't know about you, but I've run into clerks and the city people that they're not going to have this conversation with you. But
I understand that. But they are going to manage to make the assertion, right?
Yeah, of course.
See, they want to make an assertion without any question. That's everybody. That's every cop, every bureaucrat, every judge, every clerk, every politician, everyone who wants to spout shit. Wants to make their assertion as a parting shot.
I've been city clerk for quite a few years, and the only way that you're going to be heard by the next judge is if you put up your bond. If you want an appeal and you want to be heard, what do you want to do?
Before we get to that stage, I'm trying to clarify what the current situation is. I'm not yet interested in talking about the next step. I'm trying to figure out what the current situation is. Can you help me clarify this? Because there's some muddiness in this record here.
Sir, I'm not here to. I can't give you legal advice, sir.
I'm not asking you for legal advice. Please don't give me legal advice.
Sir, I'm not the court. I'm not here to argue with you. All I know is I have the only option you're going to have is to is to pay the bond so that you can be heard at the next date, or don't.
Well, I again, you keep going to what's next, and I'm trying to clarify what is currently the situation. So if you would please put off the topic of what's next, I'll decide that on my own. I don't need your advice. What I need from you is the current state of
security.
What's going on.
Security, could you remove this man, please?
And you're presuming I'm doing this in person. I'm doing this by paper.
Oh, okay. Interesting. So like a motion to the clerk.
Kind of. A request for clarification of the record.
From the clerk. I never heard of that. Interesting.
I've done it several times.
And the clerk does have.
I had clerks sending me paperwork constantly about who my judge was going to be, and I'd ask for clarification. I said, I didn't actually request a judge of my position. Who is this person, and why is he judging anything at all? And suddenly dates would go away, and new judges, and they'd come back and do it all over again.
Wow. These are angles I've never heard of, Gary. Sorry.
Here's the thing. Well, it was very strange. The biggest strange thing that was going on was people who were telling me I was crazy, right? I'm getting this paperwork back from courts, and I'm going, now how crazy is it that I'm saying this doesn't make sense, but they keep backing off, waiting a minute, and writing me a whole new set of paperwork making the same assertions, And then I ask for clarification, and they back off, and
from the clerk.
It again, and clerks and stuff.
Wow. And I know the clerk, I mean, if you read what the clerk is supposed to do, they really are kind of between you and the judge. They do have responsibilities.
Their responsibility is about the record and what's going on and keeping up that, And again, their responsibility is what is the current status of this, what's going on. And you're like, well, you just as simple as, hey, why don't we have a hearing scheduled? Well, because it's already been disposed. Really? Was there a hearing without my presence? No, you were there. Really? Because I don't have any record of any hearing.
That's fucking
slick. You see, you're getting them to stick their foot in their mouth.
I never thought of
even. Wait a minute. The only thing I had was this informal thing that had no due process with it at all. Are you calling that a hearing? Yes. Wait a minute. Doesn't a hearing have due process? No. Wait, are you sure? What are they going to say? Yes or no? You know what I mean?
That's a pretty
You're backing them into a corner.
Huh. Well, there you go, Paul. I mean, Monday is going to be gravy, brother. It's going to be no, seriously.
Well,
this thing with no pressure because there is no pressure. Either you're going to get it resolved by sticking to what you did and going around and around as whoever was on that. I think it was Dan that was on your call there, or Robert that said Mark is like a broken record. That's what I like about him.
Well, let's not get into that for the moment. Hey, guys, let's keep this recording a little bit on focus there, not get into any...
Right, I just wanted to see if we can we just, sorry to interrupt, Gary, but can we just summarize, is it or is it not worth asking about a transcript being made?
Okay, sorry, let's too long didn't read that. Let's summarize that down. My contention is your real concern is not about whether there's the cassette tape being made or somebody taking notes officially. My point is that the underlying point is whether or not there's any review process about the actual events that go on rather than just the judge's summary, feeling at the end, right? And I wouldn't be comfortable, just like everybody else, with something that the only thing was the review at the end is the only thing that's being appealed. I'd want the actual events and the sequence to be subject to appeal.
Well, let me read what I did some research on this earlier because I was thinking about it, and Tom's script that he put together, the first question on there got me thinking about it. And also, they make some relationship between courts of record and ability to do contempt. Anyways, but it says 800.13 recording in municipal court. 1. Every proceeding in which testimony is taken under oath or affirmation in a municipal court shall be recorded by electronic means for purposes of appeal. Now they're not going to be taking testimony at this motion hearing. Okay? Then it says 2, notwithstanding subparagraph 1, a municipal court is not a court of record. So
again, stop conflating recordings and record.
I'm not conflating it. I'm trying to let you know what I have learned about what they themselves say about. They're saying that if there's going to be testimony under oath, that there will be recorded. They will record the testimony with electronic means. If there's no testimony under oath, they're not going to record the testimony with the electronic means. That's all I'm trying to point out. That's what their legislation says.
Hold on. Even in a civil infraction case, there will be testimony by the cop right away. The first thing.
The cop isn't going to be there, Tom. This is just going to be the motion hearing. The cop isn't going to be there.
Okay, that's right. Yep.
No, and I'm not trying to argue with you.
Paul, who's going to be there? Is there a prosecutor?
The prosecutor is going to be there. The clerk is going to be there, and the judge is going to be there.
Okay, then you got to get between the judge and the prosecutor. You have to use the motion to get between the judge and the prosecutor and insist that the prosecutor produce the evidence that the cop had jurisdiction over you when you were stopped.
Or confess that none has been presented.
Or how about this? Hold on,
Yes,
I gotta say this. Paul looked at, because I heard it on the recording, and I've done this. You, Paul, looked at the prosecutor and started asking questions because the judge right away snapped in there that you are not to ask her questions. And that's something
you could be looking at her, but phrasing it in the open, right?
Yes, exactly. Stop looking at the judge. Look right to your left and address all your fucking point of clarification. And look at her. And we don't care who gets the question. And the judge is going to say, you don't ask her questions. And don't even respond.
But if you phrase it in the third person, then you're not asking her a question. You're saying, you're looking at the prosecutor and saying,
does the
prosecutor?
Yes. Look at the prosecutor. Quit looking at the judge. It really throws things off, man. That's when I asked Kelvin, remember you heard that. So do it. It throws everybody off. When you're looking over at the prosecutor and the cop or whoever's accusing you, and you quit looking at the judge and quit arguing with the judge, it fucks everything up. Try it. Monday, you're going to be able to try this shit, man.
Okay. All right.
I'm serious, because I saw it. I heard it. As soon as he did, because I heard it. You don't look over there at her. You don't ask her questions. Actually, she's the one. Remember, Gary, you heard me say I had that epiphany. The judge cannot testify. The judge is your referee. The prosecutor is the one accusing you. Everything you have to ask is toward the prosecutor. Almost ignore the judge.
Here's I'll clarify. I'll go beyond, step beyond that. It's about what evidence the prosecutor got from the world and is presenting to the room.
Right. And the room, the judge is the room. That's the beauty of it.
Incorrect.
He's the court.
Incorrect. No.
Okay.
You're absolutely wrong. Whenever the judge says the court finds, he means everybody involved. He's trying to speak on behalf of the group, and he's trying to shove words in your mouth by doing so.
Oh.
So if the court finds that you were guilty, you were part of that. So, but you can ask, what is the court if you want? If he says the court, you say, are you calling yourself the court, or are you calling all of us the court? What is it you're calling?
Remember when I challenged this last bitch when she said, "This is my courtroom. You will not make a kangaroo court out of my courtroom." And I asked her, "This is your courtroom, your personal courtroom?"
Don't conflate court with courtroom. See, you got to watch these words that are similar aren't the same. People keep slipping back and forth, and they're very, very different. Recording, record, courtroom, court building.
Nothing but a word game.
Okay, well let's see if we can take the Dan mentioned some advice that Dan, you gave me that same advice before my first hearing date, I recall too, and so we have there's a number of scenarios that could unfold on Monday. That the judge could say, I've received the prosecutor's response to your motions, and I find I'm denying all of them, right? And so I have. Let me just, Gary, hang on 1 second. So I can either say, I could take a strategy. Okay, I'm gonna try to fight these motions, or I can just say fuck the motions. I'm going to the 1, 2, 3. And that's because I remember last time, Gary, we had that talk, and you said, you know what, Paul, you think you might have done better if you wouldn't have even had the motions because you were so exhausted with arguing motions
That's true.
that you fell apart when it came to 1, 2, 3. So from a high level, sorry, let me just finish this. From a high level standpoint, should I spend time on the motions at all, or should I cut to the chase and say, can we end this today? I'm ready to plead guilty right now. Go to the 1, 2, 3.
Well, you want to hear my opinion on that real quick? My opinion on that real quick differs a little bit from Gary. My opinion is when you walk into that courtroom, I want everything I want to say and argue in those motions. And then when the judge says I denied them, I want to say, okay, what is it that I can help you with to understand? What is it that you disagree with? Because it's very clear. Because every time they turn around and say, they'll say to you, argue your motion, Paul. Well, no, my argument is in my motion.
I agree with you wholeheartedly so far.
So my argument is in my motion. Judge, what is it that I can understand in this motion that you need not to understand? And don't say another word until you fix it out.
Okay.
My motions are clear.
How about I add to that the idea that this judge just said he received the prosecutor's response and denied your motions. Why are you presuming that the copy you got is the copy the judge got? Because this judge obviously has something you don't. He has a bona fide objection and a convincing argument and a compelling argument against your motion.
And make
I'd
him
be curious.
explain. Yep. Don't explain
I'd be
your
curious
motion.
where the hell he found this.
All my arguments are in, Judge. What is it that I can help?
No, I'm sorry. Back up. So here's this. You're at a different point in the scenario than I am. Okay, so you have your motion in. The judge just mentioned that he read the motion, he read the opposition, and he finds the opposition compelling as denying your motion.
Right.
The first question that would come to my mind, let's pretend for a minute there was an actual fair, honest guy in front of you, right? I know, right? Pretend. What question would you ask him? Wow, really? Because the copy I got was just bullshit. What the hell did he give you?
Okay.
You see, the copy I got was just nonsense, bullshit, non-answering, whatever. You must have really got something much better than what I got because you found it compelling to deny me.
What I say something?
Can I get a copy of that?
Well, but how do you? But you're gonna when he says that you're denied, you're gonna say I would say objection, point of clarification. I reviewed the prosecutor's response as well, and I didn't see any facts and evidence.
Wait. Why are you again presuming that your copy is what his copy is?
Yep.
Because she CC'd me on the copy. It says she sent it to the judge and she CC'd me. So unless she gave him a completely...
I wouldn't trust that for a minute.
Okay.
I would not trust the idea that you got the copy that the judge got. Why would you trust that notion?
Gary,
Did you deliver it yourself?
Thanks for calling. I appreciate your skepticism. I just assumed that she would have given me the same thing she sent to the judge.
My point is in this hypothetical of this story, the judge was convinced by something great that he read. Your copy is garbage. Obviously there's a difference, and I would start asking about that difference.
That's a beauty.
Wow, because the copy I got, just like with the ticket, the ticket I got doesn't have any evidence at all. Just like that. Wow, the prosecution's response that I got has no bona fide objection at all.
Yeah, could you show it to me?
Can I see your copy?
Yep,
Same thing
awesome.
as the ticket.
That's awesome.
Where in your copy? Because mine, I didn't find any bona fide objection. I didn't find anything that negated the point
that I made. Yep.
Well, that's in fact that's true. Now, how do I go about? Do I make that in the form of an objection?
No, you're asking questions, clarifying.
Okay.
Wow. Because you can't fix it until you have.
Well, yeah, it would be an objection.
Let's say an honest mistake happened. I mean, objection, point of clarification. You do that a little too much. Sometimes I just say just to clarify or something other, less abrasive. But I would be like, whoa! I just need some information here. Maybe let's pretend for a moment maybe the judge did get a good copy and he gave you a shitty copy just to throw you off, right?
Okay.
What would happen is the judge would be like, well, you didn't have any answer to this stuff, and you would have been duped, right? Maybe he went on and he gave the judge a copy saying, no, he actually, last week came into my office and signed this thing saying he knew that he was in the state and he knew blah, 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 and he knew all this. And your copy has, well, statute 487 says blah, blah, blah.
Okay.
Why presume that this judge is talking about something he got that's convincing? Ask him about it. Wow, you got something that sounds so different than what I have here.
Okay.
Maybe I need a copy of what you have, and he'll say, well, you already have a copy. Really? Are you sure? Because I don't see any of this thing you're mentioning that's compelling. I see nothing that can overcome my point that blah, blah, blah. In here at all, I'm paging through. Can you point to, for instance, my motion included the fact that he hadn't proven blah, 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 whatever. And I don't see in his response, and that one point is a crucial flaw in his case. That one point alone is a failure to state a case, and I'm not seeing even where that one is countered.
Okay, got it.
All right, I'll go with that one. Let's go with that one, Mr.
Give me a copy. Maybe read me that from your copy.
The prosecution has already answered this, and it's very similar to your last motions, and we've already gone through that, so there's no need to make any more decisions. Indeed, those motions have already been decided.
That's all great. You're missing my point, Judgy Wedgie. My point is that I don't seem to have the information that that some other people in this court seem to be alluding to.
Sir,
and I just like a copy. Maybe.
Mr. Prosecutor, do you have anything to say about that? And the prosecutor says, yes, we've already dealt with these motions. I didn't even bother to answer them because they're exactly the same. So, that's it, Your Honor.
Supposedly he has an answer to these motions.
No. What? Oh, yeah.
I'm talking about the fact the judge is talking about his answer being compelling, and I'm talking about the fact that my copy of the answer isn't compelling. That doesn't raise any bona fide objections. That it doesn't really contain an opposition.
Let me ask this of Paul. What I did was, my first time in, I gave those typical motions, all right? And then the second time I went back in, according to what you and I talked about, Gary, make some adjustments. I broke Mark's motion into 3. I made completely different motions out of all of them and resubmitted them all. Again, a bombardment. And it was a blanket denial because all the motions were the same thing that we had discussed last time. So, what I'm asking is, you already brought those motions.
Are they the same? Were they identical? You didn't change even a word?
Oh, I changed them. They were completely different, but they were the same.
Okay, so I would have an objection. I would object. It's like, so wait a minute. Just to make sure you weren't looking at the wrong copies, because these later motions were very different by many sentences worth. Are you saying that they were identical motions, or are you saying that they were that you felt that they were similar?
Mr. Capps, I've had enough, and you said you wanted to plead guilty earlier, so I'll take that. Bam! I walked off. That's what I got. So that was that one. We've already dealt with these motions, Judge, and that was it. I got railroaded big time, so be prepared for that too. But especially tomorrow or Monday. That's what you're going to get. There's no record being made of what's going on. You're getting caught.
Okay, let me just back up a minute, because I was asking a strategic question about whether if the judge would immediately deny the motions, and what I'm getting the feedback, and then I asked, should I fight the motions or should I do the 1, 2, 3? And the feedback I'm getting is fight the motions. Don't just jump into the 1, 2, 3. Try to contest their denial of the motions first. Pardon me?
The motions are valid. The motions are valid points, right?
And they are 1, 2, 3.
Once you've clarified that he is not hearing the motions, right?
Mm-hmm.
Then you can move on, I would say.
Once you've what do you mean? Once you've clarified that he's not hearing them, what do you mean not hearing?
Not being heard. That the motion's not receiving a hearing.
Like, in other words, he's made a decision, and he's decided that
In other words, he's made an arbitrary decision.
Yeah, exactly.
Okay, so but Gary, you're giving a good strategy for calling attention to the fact that the copy of the prosecutor's response that you received did not contain adequate responses.
Reason.
Yes,
it did not contain a reason to deny the motion.
Right. So
that's the whole point between it being it's not reasoned, it's arbitrary.
Okay.
So once you kind of got that.
So are you saying that after that you just fight it a little while, and when you realize that they're not good, that they're going to assert an arbitrary opinion, then you give up?
Realizing you know that already right now, but once you've made that point in what's occurred. Now again, this isn't being recorded, right? There's no recording, so the actual events specifically aren't that important. So you just say, well, I'll tell you what, he's not going to clarify. It's like, well, okay, I'm trying to investigate some missing documentation here, or some documentation that you're alluding to that I don't seem to have. I'm just going to make note of that and put that off for now. We have to come back and deal with that another way. But for now, maybe we can just cut this short and, do I have the right to plead guilty here today?
Okay.
And attack that second avenue.
Okay.
Now you haven't abandoned the idea that your motion is right, and you've let them know it. It's like, well, it's like but again, without recordings and so forth, he's not worried about his boss reviewing anything. There's nothing to review. When he's the only thing he's got to worry about is the boss reviewing his notes about this. What really does he have to worry about?
That's the point. So this is going to be a relaxed day for you on Monday, Paul. This is going to be an opportunity. It's an opportunity to get it done, but there's just don't let push number 2 until it gets a little funky and just back off.
But every decision, he's going to try to say every decision was like the court's decision and you all reasoned through it. Your point to make is that he's issuing his opinion, his arbitrary opinions in the name of the court.
And push it until it gets shitty, right? I mean, that's it.
Well, I mean, you seem to be just calling your arbitrary opinions the court's decision.
Yeah, he is going to do that.
And you object to that.
That's right. And you're going to object until number 2 starts to get a little bit scary because there's no point.
Well, there's no object to that, and he keeps doing it, and you say, well, I still object. You don't have to keep harping. You just say, well, I still object to that. Well, I still, you've made clear what it is you're objecting to.
You know what, Mr. Capps, I've heard enough of your objections. You can take that up in appeal, and I've made my decision. Get out.
What?
I've had that said to me. Get out. I've made my decision. Appeal it.
Yeah.
Well,
again, the question isn't he's presenting you with pay or appeal, and that's it.
Well, hang on. I mean, if the judge is going to deny the motions, and if because that there's no recording made, they're going to behave in a callous manner. And let me just finish. And so if the outcome is going to be that they're going to say, Mr. Mosine, you got to go to trial. I mean, I guess
what is that? You don't just say that sentence as lightly as that.
Well, that's the drift that I'm getting from you guys is that this is going to be it's hopeless. You're going to go to trial.
You're missing a very important point then.
Okay.
So when you say this is going to go to trial, what is this?
They're proceedings that they believe they are. They're trying to proceed with this prosecuting this citation.
What does it mean to go to trial? What is a trial? Let's start there.
An opportunity for the parties to present their facts and evidence to support their adversarial positions.
Okay. So, in order to be ready for trial, what would happen? What would need to happen in order for you to be ready for trial?
Travis just said something really good. He just typed it. Paul, You can't be found guilty on a motion hearing. Just remember that.
You know, that their whole goal is to push you into trial and make it look like you are informed, right?
Yeah, and the trial, just because they call it a trial,
which causes
shit.
me to skip that question I was just asking. I was trying to get Paul to actually say it.
Well, just because they call it a trial doesn't mean it's a trial. It's up to you to be ready for a trial, or let them make it a trial.
It's not. It's up to them to be ready for a trial. Part of their obligation is to make you informed.
Right. I'm saying don't
before
accept
the trial.
I'm just
before
saying
the
don't.
trial.
Well, yeah, it's going to be another motion hearing.
You cannot be in trial without being informed.
I agree, Gary. You know what? What might be a little confusing right now, I've been listening to you for a long time. I don't know how long Paul's been listening to you, and Paul seems to have a question right now that says, he just said, what am I just fucked when I go to this thing, and then I go to trial? That was what he said.
Because he's missing the very important underlying point. They want to make it look like you're fucked. It's which way kind of fucked you're going to be. That's the whole question that they present you is, which fucking are you going to take?
What I'm saying is this. What I'm trying to make clear is this. Because he's in a court right now that's not making a transcript, they'll schedule it and call it whatever the fuck they want. They can call it your execution. I don't care what they call it.
Right.
The next step is going to be in front of a real judge with a record, a recording, a transcript being made. And the shit will be a little bit more serious.
Call this
another arraignment
attempt if you want. Yeah.
Another arraignment. It's an
arraignment. It's
an official one. An official one on fucking paper.
Okay. So does an arraignment need to be recorded?
If you want it, yes and no. I mean, at least this now the judge is going to say, well, I do have a recording being made. The one he's got now is going, ha 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 ha. I can do anything I want. I can shit on your fucking head. Nobody will know it.
So to set something for trial, okay, what does that mean has happened? That they booked a date?
Yeah, who cares?
No.
That's what I tell them. Call it whatever you want.
You can book a date for your wedding without having asked a person to marry you, correct?
Gary, I'm getting past the point of where he's argued and had his fun on Monday. And now when it's over with, when he's asking, what the fuck? Do I just lose and go to trial? No. You go to the next step. He's going to the next step.
The same step. Looking for clarification.
That's right. You're right, but now it's going to be in front of a judge that actually has a little bit.
I don't care if it's in front of a janitor. It's always the same question.
Yes, it is, but there's a little bit more pressure on them, is what I'm saying.
Fair enough. The more formal they need to keep it, the more they need to keep it by the book, the better for us.
That's all I'm saying. It's not that you're fucked, Paul. It's not that, oh God, I'm fucked. I'm going to trial. It's up. No, you're gonna move from a court that is an kangaroo court to something that's a little bit more legit.
Yeah. They want you to go to trial without clarification. That's their whole goal in life, right?
Mm-hmm.
Yeah.
You're bringing up these clarifications, and they're not wanting to provide them, so they want you to go to trial without them. Your whole goal is to point out, wait a minute, I have the right to be informed. That means no muddiness, no vagueness in what I'm accused of. All vagueness that I point out should be clarified before trial. Are you forcing me to trial with this vagueness in the accusation that I've pointed out already? Why, yes, we are. That's the whole round trip.
Okay.
I'm raising vague points. I've been accused of something and something was left vague.
Okay. All right.
And there we are. And now this is an arraignment. Let's call it an arraignment attempt. A motion. There's always your side is the motion, their side is the accusation. That's the whole of arraignment. You're trying to say, hey, by the way, demurrer is the appropriate thing to do. The judge is saying, I don't feel like it. The prosecutor's saying, hey, let's schedule the trial. And you're saying, hey, how about clarifying this?
Yep.
I have a demurrer, clarify, You pick which one you're going to do. Both are, since demurrer you're not going to do. Demurrer is recognizing the fact that the prosecution's failed to state a case.
But isn't a demur also a motion?
It's when you clarify that the prosecutor's not stated a case, that is called a demur. If they agree with it, then it's this case dismissed.
Yeah, okay. It's a motion. God damn it! It's a demur in California. It's a motion in Michigan. You know what I'm saying?
Well, and sometimes they'll say we don't accept demurs and we don't accept blah blah blah. It's a challenge to jurisdiction. It's actually it's by definition it's a standing challenge, if you want to call it that. I've phrased it in the form of a counter complaint. I've phrased it in the form of a what do you call it?
Well, irrelevant. It doesn't matter.
Well,
at this point right now, would
I've
you
done it as
agree?
non-motions. Yes.
Well,
Would you agree that Paul is in a situation where he can have a little bit of leeway on Monday, try to get this thing dismissed, don't back down, go at it, push number 2 lightly because you could disappear on Monday.
So this is fully for you. This whole ordeal is your show. All they want to do is skip it and get a trial or get the next step scheduled, whatever that is.
Okay.
It can be a scheduled conference or whatever. They just want to be able to check off and say you had your day. They might sit down and say it's denied. We set this for Tuesday. Have a nice day. Really, that might be enough for them to check off their box.
okay. But
and that's all. That's a no-lose situation for them. They might just want to do that. That's what I'd want to do as a judge.
And now where does that leave Paul?
Paul needs to be on the ball of saying, "Hey, I'd like to resolve this today." There's a couple quick ways that might just do that.
right. So it sounds like just from a high level, I should contend the motions and as long and as much as I can, and when that if that comes to a point where it's just they're just obviously not going to entertain any questions, any clarifying questions anymore, then I go to the 1, 2, 3, and just treat it as an arraignment. No, that's not true.
I agree. I'm sorry.
Yes, and do it until the number 2 becomes dangerous. Just keep going round and around until number 2 apparently becomes dangerous because they got nothing to lose.
Well, I gotta be in Ann Arbor Tuesday morning at noon for that art show, man. So I can't get thrown into jail on Monday night, man.
And you can say there's nothing wrong with saying it's like, hey, I don't feel it's safe to say anything further here. Maybe we should just kind of call this a day here,
Right. Okay.
And they'll say, okay, well, we'll schedule this. That's a win for them. You're offering them a win, but you're poisoning the well. You're saying it's because of safety concerns, not because they're right.
Well, that's the number 2. You're going to bring that up when number 2 keeps coming up. That is number 2. You keep bringing up number 2, and that's one thing I like about that Robert Landon dude. He knows how to bring that number 2 up and make it apparent. He's good at it. Keep reminding them that there's violence involved. That you're afraid.
Sure.
Hey,
talk about your
I totally understand what's going on here. I'm asking points of clarification. It's not that I don't understand. I totally understand, and I also understand that I'm being threatened, and I'm feeling very uneasy right now.
They don't want you to talk about your fears. Every time anybody's ever brought up their fears, the judges started getting really antsy. Every YouTube video I've seen, even from outside of our groups, the Moors in court and stuff like that,
I've sensed it myself. Every time I've asked the judge, are you threatening me? Dude, they turn this fucking thing around like you wouldn't believe. You ask them that question, you wouldn't believe what they start saying to you. Oh, no. I'm the fairest judge.
Not threatened here.
Yeah, you're not forced to be here. Not at all. They'll say anything.
You could have not shown up. We would have just done our deal.
Why don't we, if you guys don't mind, why don't we give us another try? I think I was pretty crappy at the first role play. I was tongue tied and stumped right out of the gate. I mean, it's getting late, and for what the strategies that you're recommending are fight. So let's give me another chance here.
Clarify. You're calmly taking notes.
Right.
Right, and keeping a relevant and unanswered question on the table at all times.
Okay.
Whether you're clarifying about why he's denying the motion, or where the hell this opposition is that he's talking about, or whatever.
Well, let's try it one more time then. Let's start from scratch again, and Tom or Gary, anybody want to be the judge, just let it rip, and we'll try it one more time.
And I will yell at you every time you don't have a relevant question on the table. Okay.
Okay. Yeah. Please do.
So Tom, give him hell so I can get on to him about not having a relevant and unanswered question on the table. Simple, nice, easy one.
All right. Again, Mr. Mosina, I have this record in front of me. It's very limiting of what I have. I see that you were at a motion hearing right now. There was a not guilty plea entered for you at your last hearing by your former judge, and I've read your motions. I've read the prosecution's responses, and I deny your motions. So how do you plead? Or no, excuse me. So we're going to set this for trial because your plea is in. So are you ready for trial?
Wow, I'm surprised, Judge. When I reviewed the response from the prosecutor, I didn't see any facts and evidence to address my question about the applicability of the codes to me. Did you find something? What did you find in her response that proved that?
Well, sir, I reviewed some of the motions that you had in prior, and these seem to be very similar, and the prosecution answered them adequately, and I denied them. So are you ready for trial?
Objection. Point of clarification. I asked her specifically to present evidence that the codes and statutes of the state of Wisconsin applied to me, and can you show me in her response where she actually presented that evidence?
Well, again, that those are issues that can be brought up at your trial. So would Tuesday sound good for you?
Objection. Point of clarification. I'm challenging the prosecution's claim of jurisdiction, and I can challenge jurisdiction anytime it's asserted.
Nope. Question.
Okay.
Back up and ask a question instead.
Right on. Let me try that again. Objection. Point of clarification. Is it not true that jurisdiction can be challenged anytime it's asserted?
Oh, yes, sir, and you'll be able to do that at your trial.
But it's objection. It's being asserted. It's being asserted right now.
Well, with everything I have in front of me right now, with the decision the judge prior to me made, he entered a not guilty plea. Apparently, there was a jurisdiction, and we're setting this for trial. I'm not quite sure what you don't understand. You want your fair day in court, don't you, sir?
Well, I'm not ready to go to court, and I have the prosecution is the prosecutor is failing to prosecute. I have.
Back up and ask that as a question.
Thank you, Gary. Objection. Point of clarification. I'm asking specifically where in the prosecutor's response did she enumerate the facts and evidence proving that the Constitution and codes of the state of Wisconsin applied to me?
Well, I mean, I read her response, and it seems that she says that these are the same issues you brought up prior, and the judge denied your motions prior, so I'm going to go along with that. So I really want to set this for trial date, sir. Becoming very impatient.
Objection. Just a point of clarification. Are you asserting facts not in evidence?
Why did you abandon your question?
Well, that's a good point, Gary. I'm not abandoning it. I'm saying that the implications of him not answering the question are that he's asserting facts not in evidence.
Oh, okay, but you asked a question and he gave you a little spout, and you went on to another question. So
well, you're right though. But I thought doesn't this question? Sorry, Gary, but doesn't the question I asked doesn't it logically follow though that he's asserting evidence that doesn't exist?
But you didn't get the answer.
But you didn't get an answer. You just abandoned the question.
Okay.
So you ask a question. I don't care what the question is, right? I really don't care what the question is.
Broken record.
The better questions are better.
Okay,
I prefer you, but if you ask a question and Tom in this, he goes off and he talks about whatever he talks about, right? And you have built a new question based upon what he just said. He's leading you around then. So you have these questions that it seems like he's answering your questions is what the record looks like, or well, not the record, but is what it seems like.
Okay.
You're making it seem like he's answering your questions and he's not.
Well,
so you say, well, that's we can address that in a moment, but my question was.
Well, you're right. And I have a habit, I guess, of of looking. When I face a brick.
Conversation.
When I face a brick wall, I'm trying to find a way around it instead of just like the Mexican standoff, like Robert and Gary, like you said last time. Just keep hitting the same question if you have to do it 50 times.
You're pointing out that it's a simple question. He's not answering it. It's like, why are you? At some point, it's like, well, why are you? Is there something you're not hearing about the question I'm saying? You know, it's if you keep wandering around with your questions, he's going to get tired. It's like, listen, you're just asking nonsense. You know, you're just asking questions that aren't going anywhere. But if you ask the same question, it's like, well, and it'll start saying, well, I'm answering your question already. It's like, well, I didn't hear the yes or no. It was a yes or no question, and I didn't hear a yes or no. So then you have that additional point to say, well, I'm just not hearing your yes or no answer. But if you wander around and readjust your question and try to find a new phrasing and try to convince him to answer, then you could never come back to that point and say, well, I've been asking the same question in the last 5 minutes, and you've just been giving me a dance instead of answering.
Okay.
So I think that's important.
Yeah, it's a bad habit I have of
abandon every time you change your question, you abandon the other one.
Right. Okay.
And you're confessing that it wasn't good enough.
Okay.
Because you abandoned it.
Well, all right. I hear you. Tom, do you want to do instead of me asking if you're asserting facts not evidence, I'll just repeat Mr. Judge,
you're working off a list of questions, so you should be reading these ideally verbatim from your list, right?
Right.
You have the now, Paul. You have that small script I gave you. And
yeah.
I hate scripts, but this one is so short and simple. It boxes them in, and you didn't use any of these yet. And this judge is new to you. You can actually go with the first question, second question, go right on down the line, and take your time.
Oh yeah, you should do the setup questions.
Absolutely.
Say, hey, do I have, because the answers might have changed. You might no longer have the right to be informed of the cause. You never know.
Okay. I see. I got off on the wrong foot. Okay. Well, should we start? Do you want to try it over again?
Try some of the setup questions right after denial. You can, if he says denied, it's like, well, do I have a right to a meaningful hearing on these things?
Mm-hmm.
He'll say you just got one, for instance. But it starts the conversation up.
Well, here, let's try this. Paul, you play judge for a minute. I'll play you.
Okay.
Right?
Okay.
Okay. Here's my first clarification question. Judge, I intend on entering a plea. I've been trying to enter a plea since we started this thing. The prior judge entered one for me. And you did enter for a second here. You did enter a vacate plea motion, did you not?
Yes.
Paul?
Yes.
Okay. So I entered
sorry. That's new information. Can I stop?
Sure.
Okay. I didn't realize this.
I didn't either.
One of the motions that he's going to deny is the vacating of the plea.
Sorry. Well, that's on the table. Yeah.
Okay. So I would discuss that one in particular.
Okay. Well,
it's like, so are you saying that plea is in, that plea doesn't interfere with my, right to be informed of the cause and nature of these proceedings? Because that's my concern.
Okay. You're playing the role of the alleged defendant, and you're saying what? Can you repeat that?
For instance, that's a question that comes to my mind.
Can you repeat the question though?
Okay, so he denied vacating the plea, right?
Okay.
And you say, so you're saying leaving that plea in place doesn't infringe on my ability to be informed of the cause and nature of these proceedings? Well, no. You still have. So what I'm saying, I'm pointing out the difference between having that plea in and not having that plea in, right?
Mm-hmm. You're saying there's no difference.
That plea in place and not having that plea in place is, in one case you can get clarification on the cause and nature of the proceedings, and in the other case you supposedly know them.
Exactly. That's why I wanted to kind of figure out if I needed to make sure I get that plea vacated so I can get back to square one in the arraignment process.
So I'm addressing that point directly with this judge. He's saying, "Oh no, it doesn't hurt you to have that plea in, so I'm not going to vacate it." And I'm saying, "Wait a minute. Okay, so you're saying since it doesn't hurt me, that I have the same right to be informed of the cause and nature of these proceedings?"
Oh, I got it now, Gary.
With that there versus not? Great, if that's the case, let's go ahead and do that.
Okay, I got your point. I got you. So
then I'd say, well, do I have the right to? Okay, great. Thanks very much for telling me that I have the same right to be informed of the cause and nature of these proceedings as before.
Well, I mean, now what's the difference, Gary?
I have the right to be guilty anyways. So
right. What's the difference between simply asking the first question on the do I have the right to plead guilty here today?
They go hand in hand. So let's say he won't vacate that plea, right? But you clarify and you say, do I have the same right to be informed as if it was there or versus not there? And he says, you have the same right to be informed. Ah, great. Do I have the right to plead guilty here today? Yes, you have that right too. Great. Then you know what? That having that plea in there isn't hurting me today if that's true. Given what you just told me, we're good. So now I have some questions to clarify the cause and nature of these proceedings. When he gets around to not wanting to inform me anymore, oh, do I still have the right to be informed of the cause and nature of these proceedings? No, I lost that right somewhere. Would I have lost that right if that plea had been vacated? So there was a difference. You see, I'm boxing in the logic a bit.
I'm writing notes here. I do see it's a very good way to address it. So you're not arguing his approval or denial of his denial or.
I don't care about the ceremony. I care about the impact.
Exactly. Right. Okay.
It's like I don't care if officially there's a flag waving that says you plead guilty or not guilty. I don't care about that. I care about the effect. The effect of having a plea in is that then they start going on about not informing you of the cause and nature of the proceedings.
Assuming you've already been arraigned.
I'm bringing that up. When he says, I'm not going to vacate that plea, my question is, okay, does that affect my right to be informed of the cause and nature of these proceedings? If he says, yeah, you don't have the right to be informed, I say, well, okay, so that plea is an injury to me that you're permitting here and that I've asked to be vacated because of it, because it's an injury.
Right.
Just to be clear, you're intentionally injuring me in a way that you shouldn't be, or there's no justification for.
Right, and then okay.
Just because some prior judge wanted it that way.
Right, and then so, but what if he just rules that the motion that he's denying the vacating the plea?
Again, I'm sidestepping that whole issue by asking about, do I have the right to be informed of the cause and nature of these proceedings? That aside, or has that changed because of this ruling?
Okay.
Or because of that plea and the failure to vacate?
But what if he goes and like you said, what if he is injuring you and what if he says you were past arraignment, you've already been informed of the nature and cause of these proceedings? I mean,
of course I'll say that. I was like, okay, just to clarify, do I I have some questions to clarify the cause and nature of these proceedings, and my first question is blah blah blah, and you go right into your question.
Okay.
And if he doesn't answer it, the question becomes, okay, I asked for a clarification about the cause and nature of the proceedings. Do I have the right to know these or not? To be informed, I should say. You see, to be informed isn't just in the high-level abstract. If you point out something that's vague and they don't clear it up, you're not informed.
Mm-hmm.
If I tell you, I like that car you used to own. And you say, well, which one? Well, never mind. I told you what car I liked. No, you just told me that you liked a car that I used to own. And I'm asking you, I own several. You weren't clear.
Mm-hmm.
And I go on saying, no, I did inform you. No, I didn't inform you of what car I like.
Mm-hmm.
If you only, so it was a vague point that you're trying to clear up. And that's what point of clarification means. Something vague was said, and you're trying to clarify between a couple different possible meanings.
Mm-hmm. Yep.
So the cause and nature is vague. If it's not vague, you need to write a book, because it means they've informed you of what stare decisis impacts things, what appeals processes there are, what interlocutory appeals processes there are. All these things have been known to you somehow.
Mm-hmm.
And they might just say, well, you don't give a shit about it. You've been informed good enough for you. It's good enough for us.
Hey, Paul, just like number 8, what rules, if any, govern these proceedings?
Yeah.
Mm-hmm. I mean, that's why I'm saying.
And if they say read up,
does this court have to comply? Does this court have to comply with all of these rules? I mean, this script that I wrote down is right off of that guy on Paranoid. That was so fucking perfectly put together with very few questions, because they will shut you down. You got a long way in there. I got to tell you, Paul, you got a long way in there. Because you made logical questions or objections. So, and whatever. I'm just saying, this script right here, I think will keep you on track. And I've made enough space in there where you can write it down and you can set the cadence of this fight.
Right.
Act like a retard almost.
And can I make one little suggestion, like just as a matter of like how you're phrasing things there, Paul?
Sure.
You commonly say objection, point of clarification, and that's fine, especially if they're rambling on, if they're trying to move into a new topic.
Okay.
But if they've stopped and you're just saying, well, objection, point of clarification, that after the first time or so, you might just want to back it off a little bit to say, well, just to clarify, blah 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 or blah blah blah.
Okay. Okay.
Because it means the same thing, and if
all right.
I understand. It's especially if they get to rambling. Objection is
well.
The only way.
I guess I was taking your advice that I didn't say that often enough last time. I was taking it overboard. I was going overboard, but there's a happy medium. Yep, I can appreciate that.
A happy medium. Yeah, it doesn't need to be the start to every sentence.
Right.
You can say, well, just to clarify.
So, if it was recorded and you didn't begin your statement with the word objection, I kind of thought you said that anything you let go by without objecting to it was done.
Any assertion, that's true. So anything they say that asserts a legal or factual truth should be objected to.
Oh, okay.
They're just clarifying things.
But then you want to say the word objection.
Well, if they say,
Okay.
If they say you're here voluntarily, let's say they say you're here voluntarily. You came here voluntarily. You can say, I would say then, hey, objection, point of clarification. By voluntarily, do you mean that there was actually no threat of violence if I didn't show up?
Right.
So objection, yeah, there's a certain trigger, But if they just said, you have a copy of this paperwork.
Sure.
Well, just to clarify, I didn't find what you're referring to in my copy.
Right.
Can you please give me some indicator of where and what you're talking about so I can be sure that my copy matches yours?
I think what you're saying is just don't be so mechanical. Just be a little more natural and
maybe. Yeah, maybe. Objections, yeah, it's a little harsh and over and over and over again, maybe not so much. Not, there's some...
Okay.
The first one, objection, point of clarification. Then after that, if he's giving a pause, maybe just say, well, just to clarify, blah, 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 or blah, blah, blah. It's obvious that you're trying to clarify a vagueness in his statement at that point.
Okay. Okay.
But if he says you got a copy of this, or you came here voluntarily, or something that's really an assertion, where you're like, whoa, you're not just informing me, now you're making an assertion. Or he makes a factual assertion. Well, you were seen here. Well, objection, point of clarification. Have you already received testimony that I'm unaware of that I wasn't here for? Or whatever.
Yeah.
He's talking like the prosecutor maybe an objection's in order. It's like, oh, well, objection, point of clarification.
Mm-hmm.
Where did you get this information that you're telling me from the prosecutor, or are you making it up now from your own knowledge?
Mm-hmm.
I mean, that's an important distinction. He's not supposed to be going from his own knowledge. See, that's the thing. Just to clarify on a little side note, the judge is supposed to refer to information that was given to him by the prosecutor only in everything he says, right?
Mm-hmm.
The prosecutor is supposed to be referring to information that he got from witnesses and investigation only, and not from his own thinking, right?
Mm-hmm.
And so when they're talking, it's like, oh, where did you get that from, Judge? Did you get that from him? Because I don't have a copy of that communication, and I wasn't present for it.
Mm-hmm. And then, how do you? Sorry to interrupt, but then how do you respond to the prosecutors asserting legal opinions as the basis for the denial of the motions?
Okay, so he is going with something he got from a legislator or a legislature, right?
Mm-hmm.
Or a judge or something else.
Mm-hmm.
And it's like, okay, he is restating an opinion that he heard from a quote-unquote authoritative source, right?
Mm-hmm.
But that isn't what you asked about. You're asking about evidentiary questions, not legal questions.
Mm-hmm. Right.
You asked, your point, these points revolve around evidentiary issues, not legal argument issues. But by George, these prosecutors and lawyers tend to think their world doesn't involve evidence. Proof is on the moon. Who cares about that stuff? We can make a whole case just by pulling together citations.
Well,
It's like someone who's wanting to write a college paper without writing a sentence. He just wants to pull together copy and paste, right?
Well, that's the gist of the prosecutor's response to the motions is that
right?
We're like two ships passing in the night or whatever. She's using legal arguments, and I'm asking she's using legal arguments to respond to evidentiary questions.
Questions, correct. So you have evidentiary challenges. You're saying that there's an underlying problem with her case. She's failed to state a case because of evidentiary failings. And she goes about saying, my legal reasoning's sound. And it's like, no, it's not the legal reasoning, it's the evidentiary failure. It's the foundation issue.
Well, that's the heart of the matter that I need to get on the table when, if the judge were to start off and saying, hey, I read the prosecutor's response and I agree and your motions are denied.
His legal reasoning is approved. It's the prevailing legal reasoning of the bar, and I find no problem with that. So he's sidestepping the fundamental. So step one is, what facts are we going to analyze? Step two is, what notions are we going to use to analyze it? But they're skipping step one again. You're not challenging the legal reasoning. You're challenging the factual basis. You're saying, well, it's arbitrary to even get into legal reasoning. If you're going to ignore facts, any legal reasoning must be arbitrary and can't be reasoned.
Right. Yes, that's right. I remember I took a note from you. You said that if an assertion cannot be, if an assertion is irrefutable, then it's not evidence based. It's belief based. Or you didn't say belief based, but you said if an assertion is not refutable, it's not evidence based.
Well, yeah. If they say, is that assertion irrefutable? Again, it's
Gary. The point would be like if she's gonna assert that statute 800 gives them commencement of action, blah blah blah, and they're saying that these assertions that these laws apply are irrefutable.
Yep.
Then
beyond that, it's not just irrefutable. Is it challengeable?
Mm-hmm.
Can I challenge this assertion and point out that there's no evidence in the record right now, in my hands, if the record is not really there? I have no evidence that these assertions are true, and she's only provided me other assertions. So
Right.
I am left completely without any response to my challenge. The actual challenge is there evidence of the truth of this? And she just went on to say there's other people who agree with her.
That's it in a nutshell.
Right?
Okay.
So when the judge is saying, well, that's true, she has a lot of people who agree with her. Well, that's not the issue. The issue is, are her allegations true, and is there any evidence, any, real world, manifest world evidence of the truth of these? And if not, then just confess it. Just say, no, all there is are the opinions of other people. That's the end of it. If she would just say, all I have are the opinions of legislatures and judges, and I have no physical evidence whatsoever, you could move on at least. And you could say, thank you for your candor.
And then I go on to number two. Then I go into number two, and just say, are you going to enforce your, you're going to enforce your will on me with violence and coercion? Well, then,
yeah, and it still comes to the same problem. So basically that means that jurisdiction cannot be challenged, right?
Mm-hmm.
Can jurisdiction be challenged? So the question becomes, can the jurisdiction of this court be challenged? And if they say no, it's like, great, can I get me one of them courts too, where jurisdiction can't be challenged? I have a lot of stuff I'd love to file against the prosecutor.
Right. Right.
And you know what? Number two seems to be a thing that has been brought up before of how to apply it. And I can see with what Paul just said, he's a little bit lost on how to actually emphasize that number two with the statement he just made.
Yeah, it wasn't very clear, Tom. You're right.
Let's do that again.
No. Well, I mean, because I've heard you, Gary, bring up some really good ways of emphasizing number two. And then that Robert Landon dude, that guy was the best one at doing it, man. Because Paul just asked, Paul, you try to rephrase what you just asked.
It was wimpy, Tom. You called me out on it. I'm not gonna hide. It wasn't. Go
ahead and beef it up a little bit.
No, it wasn't that it was wimpy. It was that you're not sure how to do it, and I wasn't either for a while. And it takes a little bit of a. It's also a thing that needs to be learned. You can't, asking if you're being threatened, and not too assertive and threatening to them. And Gary's got some good ones.
One thing that comes to mind is saying something like, do I have basic human rights here? And does my consent? Does your claim?
See, you're bringing in new terms when you do that, and that's.
Yeah, I didn't like that either. I heard you say that before.
Okay. Well, I was going to say, do I have basic human rights here? And does your claim of
human rights is an undefined term? He could say yes, no, fargo, or anything. And
okay.
It's perfectly fine.
Okay, well, do I have the right to be given notice and opportunity to respond?
Am I?
Than that. You can't come up with an easier question than that.
I'm trying.
Can I plead guilty right now if I wanted to plead guilty?
Well, we're talking about number two, though.
Yeah, and I'd say that, and then say, am I able to be informed? Am I entitled to be? Can you take an uninformed plea from me, sir?
Well, that's more of a number three thing. Number two is more like.
Okay.
Number two is a little bit more like, will I be forced to plead if there is no evidence of even with no evidence of jurisdiction?
I did ask that question in my first hearing.
I don't care. Anything you've asked in prior is out the window.
I know. I'm just saying though that I'm just trying to say that I'm not a complete idiot. I did think of that in my first hearing. Will I be?
Paul. Hey, Paul, I've got a perfect example for number two, right? So in my motion to reconsider the demur, the judge said, I gave you my ruling. I'm ordering you to leave. If you do not leave now, I'll have you physically removed. My response was, why are you threatening me with violence for clarifying on your decision?
Right.
What did he say?
He didn't say anything. He just said, that's it, you have to leave now.
But Travis, the distinction though was that if you're responding to an overt threat and we were discussing how I can bring up the issue of violence without responding to an overt threat.
Well, anytime he says anything that is, I don't want to put this. Anytime the judge says anything to you in the form of
a demand,
you being there under your own will, right? You voluntarily going there. That's when you throw in the number 2. You wait a minute. If I didn't sign the ticket, you're telling me a man with a gun wouldn't kidnap me? If I didn't come in today, would a man with a gun come to my house and kidnap me? Yes, I think that's what Gary's trying to say with the number 2 is
certainly.
And
furthermore, if they say we're going to schedule this for trial on Thursday, number 2. Okay, so you're telling me that you're forcing, rather than resolve this today and for me to be safe tonight, you want this to be looming over my head for the next week so that we can reconvene and I have to come out here again, make my way to here for something that we should be able to resolve in the next couple minutes here. If you just answer if you would just clarify.
I would like to address the answer that Travis gave, because I used that exact phrase. I said to the judge that if I didn't show up here, I brought forward the violence, and that if I didn't show up here, that I would be arrested, blah blah blah. And the judge said to me, no. If you didn't show up here now, there would be another notice sent to you. She totally played it off.
Yeah.
So they will try to
because he only talks about the next step, not the end result.
Right. Because I tried to hold it to her. So you're saying to me that this guy wouldn't come after me? And I've made mention several times in court. I'm only here right now because that man standing right there has a gun, and if I didn't show up, he would come and get me. I've said that in court. Oh no, that wouldn't happen. They are really adamant about not letting you think.
Here's a sidestep to that. Here's a way to get around that. It says, if I tried to exercise a right of avoidance of you, would you not escalate to the point of forcing me to interact with you?
No, sir, you're here voluntarily today. Nobody forced you to be here. She said that shit to me, dude. I tried these things. They step all over it. You came here voluntarily.
I understand that, Tom, but the point I'm trying to make is any time that they try to force you to do anything, that's when you bring up the number 2, right? If they're going to say the only option is for you to go to trial to view the evidence, are you forcing me to go to trial? Are you not giving me the option to plead guilty today?
Yeah, point of clarification. Are you saying that I have to go to trial without these clarifications about the cause and nature of these proceedings?
Yes, sir, I am. These issues can be addressed at trial. So, does Tuesday sound good for you?
Do I have a right to know the cause and nature of the proceedings of the trial we're talking about before I actually set foot into it?
Well, sir, if you've got these questions, perhaps you should hire an attorney.
Does this court intend to be bound to the answers provided to me by the attorney I hired?
Sir, these are questions.
That's a good one, Gary. That's a good one.
I don't even know what to say to that one.
Because I just called you on your BS, right?
Yeah, you ain't shitting. So, I mean, it really is. I mean, if you're a wordsmith like Gary and you can bring all this shit up, I don't know. They are going to try to turn this in every direction you can imagine. And I'm just a goofball sitting here, and this is easy. From the judge's perspective, this is really easy because they have the power.
All he's trying to do is get it scheduled and get you to break down and say, you know what, fine. You know what I mean? That's all he's looking for is that end, fine.
And he's going to use pressure of the bailiff standing there and his sternness when he starts getting pissed off. And again, with the thing you're going into Monday, chill out. Don't take it too serious. Try to win. But trust me, he knows there's no recording being made. He can tell you to fuck right off right in court. There's nothing you could do about it. He could literally say it, and there's nothing you could do about it. There's no record. So keep that in mind.
Yeah.
Well, you'll still be in jail.
I've been in 2 months.
Record or no record.
Oh, there's not,
What, Travis?
not that big deal, man.
Can you repeat that, Travis?
Just think of it as practice, you know? Just think of it as repeat practice.
Man, you're breaking up. Say that one more time.
I said, when you're going to a motion hearing, think of it as a safe practice, right? You can't be found guilty. They can't really do anything. If he denies your motion, you can refile it right after you walk out of court.
Yeah, and you should. If he denies your motion and he doesn't give you a reason, presume it's because you misspelled something. Misplaced a comma, whatever.
Exactly.
Change a comma or refile it. Because he
Okay.
didn't give you a reason why. It could have been grammar problem. It could have been he couldn't read it. It could have been his copy was smudged. I don't know.
Well,
Why
I did
presume
that.
if he didn't say it was based upon merit, why would you presume that it was?
I did that, and you remember what happened to me. So, you know, the bottom line is that particular judge, well, she got the new motions, and she asked him about it, because I had they didn't even bother to even respond to them after I broke them up and changed them. And I brought that up. I says, well, an uncontested motion it's uncontested, so what's the problem? I must be right. No, prosecutor says, we didn't even want to waste the time because they're all the same. And she agreed, and that was it. I mean, they can't.
Objection. Point of clarification. The copy you got is literally the same, or are you exaggerating for effect? I don't appreciate you exaggerating. You know, this is a formal setting here. I don't think it's appropriate for you to exaggerate and say they're the same when they're not the same.
Well, he said something like the same concept. Everything's the same concept, and she just agreed with him. And it was. You know damn straight it really is. It's just broken up into different, it's just another approach on the same concept.
But
they're right about
the
that.
same concept. So the denial, the original denial was on the concept and not the motion?
Well, the motion, yeah, I know what you're saying. The motion,
so you're in denial of the concept. You're not in denial of the motion. So it's not merely the motion that was denied, it's the concept itself is denied.
Yeah,
so the concept that we're talking about, just to clarify, Judgey, the concept that we're clarifying that you denied, the concept is the concept of jurisdiction. And
I'm denying your motion because the concept is wrong.
The concept of challenging jurisdiction is what you're denying. So you deny the concept of denying jurisdiction. Just to be clear.
What she said was the prosecution just explained that he reviewed these motions and they're identical to your last motion. So they're
Objection. If you don't mean identical, please don't say it. I don't know. If you had the identical motion, someone got some paperwork screwed up. So are you saying that you have the identical motions from before? Let's not exaggerate for effect.
Well, I'll go back to that transcript because, as soon as that happened,
I have little doubt that they actually said that. My point is that they said something that wasn't true, right?
Yeah, but that's where she said, 15 minutes ago, I heard you say you wanted to plead guilty. I'll take that, slam the gavel, and walk off the bench. So that was, that one.
An objection. If you heard somebody in here say that, it certainly wasn't me.
Yeah, well, she was already gone, and all there was is Carol or Q standing there. Q was so mad. There were 4 cops in there and a couple bailiffs because they had prisoners still sitting in the benches there, whatever you want to call it, where they hold them. Yeah. And she started getting pissed off, and they're coming at her, and I was like, chill out, man. I thought we were going to appeal. I said, chill out. We're going to appeal. I'll appeal. And it didn't happen, but it's just such a railroad job, man, that they can give you. Just be ready for that ball.
Appeal's not the right thing. If someone mishears someone else talking and puts it in as your statement and ends it, appeal isn't the right thing. Striking's the right thing. Vacating.
But when the judge walks off the bench and disappears, what are you going to chase her down? There's fucking 6 cops? I don't think so.
God, no. I like doing things from a safe distance anyways. I like doing things by paperwork. I'm not a big fan of going into courthouses. Not at all. Now, see, that's the thing, is you need to be really on the ball if you're going to try to do it from not appearing, but
well, let me
Well,
ask
like,
you
we've done
this.
that.
Now, let's get back to my point. That's the one loser that I have because she was the chief judge. I went through what Paul's going through right now. The magistrate, another magistrate because it was brought up as a higher charge. Then the first judge, and I got off on it because I had a technicality of the signature thing that I brought up. I fight him tooth and nail, dude. And then it was brought again in motion hearing. It was like 6 times before she did that. Okay, what I'm saying is, Paul, if you got to the end of your district court, your municipal court, and then district, that area, the next step up is a circuit court, correct?
Right.
Now, do you know how to appeal that? Because if these judges know, like this one did,
all right, you know what? That's enough for me tonight.
Yeah, I'm kind of burnt out too.
I've already raised my objections and blew that all out of the water, and here we are. That's caused discussion again.
Yeah,
right.
let's call it a night. But I thank you very much, everyone, Gary and Tom and Dan and Travis, everybody, Troy, everyone that was on the call. Thank you very much.
Paul,
Yeah.
Paul, don't forget to breathe.
Yeah, man. Yeah.
Yes. Slow down the pace.
Yeah.
When you say point of clarification, you can stop and gather your thoughts for a moment.
Right.
If they try to inject themselves into that moment when you're so dry, it's like, I'm sorry, sir. Am I not talking fast enough for you guys?
Right. That's going to be my biggest challenge.
You can't wait for me to finish my sentence.
Yeah.
You know?
That's going to be my biggest challenge is just slowing down and keeping it simple and yeah. Okay, guys.
Objection, point of clarification. Let me review my notes for a minute here. Let's see and you let it go. You let it kind of time.
Yeah.
Slow down that pace.
Yeah.
Can I ask a quick question?
Sure.
Have you weighed out if you do lose it and don't go to circuit, what is the maximum losses that you can have? Is this going to be an insurance cost? Is it going to be just a fine? Is it going to be a ticket?
Yeah, it's nothing to me. It's $119 and 3 points. I couldn't care less.
Okay. All right.
Yeah. Okay, guys. Well, hey, thanks a lot for your help tonight, and I might try to ping you again before Monday, but I really appreciate this, and it really reminded me of my what I need to work on. So it was very helpful to me. So thank you very much.
Yep.
Best to you.
Yeah.
Talk to you soon.
Thank you very much. Have a good night.
You too. Gary, can I talk to you for a second?